is on matters of an investigations ongoing. One of them, the Attorney General reveals a lot more details. The other two, he was very scanty with the details because they said they were still investigating. Even the first one where most of the details were revealed, he says the investigations were still ongoing. But before I start a conversation with lawyer, I was telling you about the fact that I was getting in touch with some sources at Yoko to confirm what Atacha was saying, that lawyers for the accused persons, Kobna Edubwa and his wife and one other person, that lawyers went there to see them, and they were told that first, he said they were being denied access to them. Secondly, when it was allowed, they said there has to be somebody from Yoko sitting in their meeting with the lawyer. I will ask whether that is unusual. So he finds a challenge with it. But first, the people like Yoko says they are surprised at the statement that has been issued by Atacha. They don't know whether he's a spokesperson for the accused persons or their lawyer, because on record they have never dealt with Atacha when it comes to the accused persons involved. They have a lawyer whom they have been dealing with. They give a first name, that is Dubik, lawyer Dubik. That's the lawyer they've been dealing with. Every action, every step they've taken it together with their lawyer, in the presence of their lawyer. If they have to go anywhere to collect any form of evidence, they do it in the company of their lawyer. So they don't make any move without their lawyer being involved. So they do not know Atacha as a lawyer in the case, as the lawyer of the accused persons. Okay, I think the right word is, lawyer, correct me, suspects.
Yes, at this stage, the suspects, okay. When they are arraigned before the courts, become accused.
Okay. So the suspects, the lawyer for the suspects that they know is not Atacha. No. So they are even surprised. So they don't know whether he's their spokesperson or anything. The only time they've seen Atacha is Atacha turned up there yesterday, asking to see the Attorney General. And then the deputy director for Yoko. Now, he was told that the deputy director was in a meeting. So he sat there for a long while because the meeting did not conclude in time. He left. That was the only time they had seen Atacha anywhere near Yoko. So this statement that he's issued, they are even confused because they know the lawyer they've been dealing with. They don't know Atacha as the lawyer for Kobna Edubwa and his wife or the other accused person. So that's the information I've picked up from Yoko. Once again, good morning.
Good morning, Senna.
And welcome.
Thank you very much.
Yes. First, I wanted to ask you, is it unusual for you to say, for an investigator to say, I want to sit in the conversation with your client?
It's unusual.
It's unusual?
It's unusual in the sense that there's the client-lawyer confidentiality.
Okay.
And you cannot pick an information from a conversation between a lawyer and a client and use it against the client. Okay. There were instances in other jurisdictions where lawyers visited clients and security agencies placed recording devices under the seats and got information, and those informations were not allowed to be tendered. I mean, the clients walk away free. So it's unusual. But I got the impression that you said...
that never happened.
That never happened. Number two,
yes.
Atacha is not the lawyer known.
Yes.
So it's like you walking in there.
Yes.
That I want to have a conversation with, is it Kwabena
Edubwa, yeah.
Then they will say, oh, we don't know you. Okay, for that reason, someone will sit in.
Yeah.
Granted that this never happened. I was in one of the police stations last week.
Okay.
To meet my client. He said they had difficulty bringing the client out for me to have the conference.
Okay.
So in order for me to have the conversation with the client, a policeman need to sit in.
Oh.
Yes. Luckily, I was speaking ever to the client. The police lady is a Dagati.
Oh, okay.
Then she got angry, said that speak the language that I can understand. And I was like, no. You are not even supposed to be here in the first place. So it's all good. So it's a bit, it's unusual.
Okay.
It doesn't really happen, but once you confirm that was not the situation, we can move on. But you find out that we have a lot of PR men for people who are finding themselves at the wrong side of the law.
Yes.
Our honorable minority leader has become a chief PR. Other minority members have become PR members. Then we have Atachia also writing a very long love letter, all in PR. So this should not surprise anybody, really. Yeah.
But like he's always said, when it comes to politics, majority of it is done in the public domain. Considering these matters are matters involving politicians, how critical do you think the step that was taken by the Attorney General yesterday was?
Yes, and I heard the use of the word prejudicial.
Yes, especially in the letter.
Yes, I was wondering who becomes prejudicial, the public? If the public has become prejudiced towards the person, the public is not the one going to judge or sit over the matter. So it doesn't really matter. Now, judges cannot isolate themselves to say that they don't know happenings in society. A judge cannot close his eyes to happenings in society. That is why you find that when we have situations where there are armed robbery cases on the rise, if someone is found guilty, the person is given severest punishment to serve as deterrent to others or to curb the menace of armed robbery. So I don't think that anybody is getting prejudiced at this stage. However, I feel that at a stage I ask myself, is the AG not giving too much information to them to prepare for their defense? But again, in the natural justice laws, they are to know what is against them so that they will prepare their proper defense. So
either way, all this information will be provided.
Yes, all this will be provided. And again, it becomes public knowledge. You can go, these days we get all the charge sheets photocopied and on WhatsApp platforms, etc. So either way, you get this information. So who is being prejudiced at this stage? And at this stage, it's still investigation. Except you go to court and you say A, B, C, and the judge writes down that you feel will be detrimental to the case of your client. I don't see this as an issue at all. If it were other countries, I mean, once the raids are being done, you see the FBI guys, the police giving news conference. They are giving you information. Go and sit down, sift through it, and see how you can use it to prepare for your defense. The ones that they feel will affect their investigation, they indicate that we are still investigating. At this stage, we will not give any further information. So I don't see what the AG has done as bad. However, I see it as a new era where light is being thrown into cases that are being investigated, potential cases to be prosecuted. What this does is that when the case gets to court, nobody now sees somewhere to say, hey, this is persecution. This is not right. Sorry, Senna. Market women are being taxed. My small boy just told me he did invigilation. He was paid 220 cedis, and that was tax. Yes, 220. That was tax. I'm coming to an issue. His salary is tax. He goes to buy fuel, it is tax. Then someone gathers, allegedly, that tax to the tune of $7 million to himself. Then people are on radio defending him. He finds it very weird that, hey, hold on. When you hear someone has killed somebody allegedly, even though the person is innocent until proven guilty, everybody says, hey, hold on, is it true? Let's be careful. But how come that our tax money allegedly stolen or taken by somebody, and we are not saying, hold on, let's be careful, but we are rather jumping to the defense of the person? I'm a lawyer, but there are certain cases that are brought to you, then they shock your conscience to the level that you say, hold on, you try to find out, has my client even attempted ABC before you begin to wear your lawyer's cloak? Because you are human. So I think that hands off for now. Let them leave the AG. Let the investigations continue. Senna, at the early stages of JM, you read statements here where people say, JM, don't do any development. Just go after all the monies for us. If you do that, we are happy. People sent you text messages you read here.
They still send it. It's not.
Good. Yes. So if now we are chasing alleged stolen loot, man, we got to let the AG and the investigators do their work. There's one good thing about the current crop of AG. Both the AG and the deputy are doctors.
Yes.
Now, both of them, at one stage or the other of their profession, have been human rights lawyers fighting for the rights and constitutional rights of the accused persons. Yeah. I would be surprised if my younger brother, Adam Justice Remsra Sai, will be on one side where the human rights of somebody will be trampled upon. No, I don't think he will do that. And I read somewhere last week, he said he visited even Edubuahin to be sure that he's safe, he's good, nobody maltreated him. Have we ever heard that before? Senator, you were here when E.T. Mensah was thrown into police custody with mosquitoes, etc. Yes. When they said we'll teach him a lesson. You were here, we heard all that. Let's not go back to those days. So I think that what the current AG is doing, throwing light on the information that he has, steps being taken, I think I only fault him for one thing. He said Honorable Apenyo Makin should not dare him to release the
recording of what the former BOG governor said.
I think he should have released it. He should have.
You want it out?
Yes, that would have settled a lot of things. Then we would have known that, because I watched Apenyo Makin's press conference and I'm like, you're talking about national security guys stealing 10,000 cedis? Really? For what? Those guys cannot, by their operation, be allocated 10,000 cedis among themselves. To use for their work, they need 10,000 before they work, or I can't get it. So I wish that he would have released that, because up to now, this thing has not spoken.
Yes, he hasn't. He's been very quiet.
Yes, and people are speaking on his behalf. And those are not hired or rented press, but people who have taken it upon themselves. Job they don't give you, you won't do that job. I think that AG should have helped us by releasing the recording.
Now, I feel one thing that comes to mind is, for those of us who listened to the press conference yesterday, when you listen attentively, perhaps you get the impression, because me, as I listen to the facts that they had gathered so far being put out, I drew my own conclusions on whether the suspect has had a case to answer or not. For a lawyer in your position, when you listen to what the Attorney General said, one after the other, the Attorney General then concludes by saying they are convinced that they have a strong case against him. He doesn't want to be prejudicial, but they are convinced that they have enough evidence to go against him. Do you feel, from that fact, you are not a judge, but do you feel that there's strong evidence against him?
Yes, on the surface of it, with what the AG said, you think the evidence is strong, hard, that can be used to convict. Now, there's something missing in this part of the world.
Okay.
The prosecutors must ask certain questions before they begin prosecution.
Okay.
Is it in the public interest?
Okay.
Will we be able to secure conviction?
Okay.
You watch programs, you listen to news, and the prosecutors feel that in other parts of the world, that much as it appears Senna has committed this crime, we don't have enough evidence to secure conviction.
Okay.
For that reason alone, we will not go in.
Okay.
The reason why they do that is that they sort of quantify the amount of time, resources spent on the prosecution.
Okay.
Assuming they are using private prosecutors, how much would the state have lost, knowing very well that we will not have been able to secure conviction? Now, Senator, can you imagine if this state should quantify how much went into the Oponi trial? Can you imagine, assuming all the prosecutors were lawyers being paid by private people? Or their private prosecutors being paid by the government, consultant, etc. All those witnesses. Yes, if we quantify how much was spent on their transportation, feeding them, everything, then...
Because that was for almost 8 years.
Almost 8 years. Then, if you look at the Atufosin Jakba one, where one of the Court of Appeal said anybody who is minded to do justice will not have proceeded with this case. So you ask yourself, what goes into making the decision to start the prosecution in the first place? So for me, before the AG goes to court, let those things be the guiding principles.
Okay. In the public interest.
Is the public interest.
Do you have enough to
secure conviction?
Okay.
Because if it is not in the public interest, for example, Senna is a huge man somewhere, or Senna is heavily disabled, then we're going to prosecute Senna. Then the public say, hey, come on, don't do that. He has helped ABC, over 1 million people. Their lives are at risk. Now by your prosecution, stop it. That's not in the public interest to continue with the prosecution. Or, for example, we have one of our best decorated players. Maybe we have our own Messi type. And he has done a lot for the country. Then he was involved in maybe a traffic offense. And you decide to prosecute. And the public will be like, come on, what are you doing? This is one of our decorated guys. People travel all over to visit our country just because of that. So it's not in public interest. Now, then you also realize that you don't have enough evidence to secure conviction. Because before you go to court, part of you should be saying the judge will have to accept this. But if you yourself, you have a doubt, or you have several doubts as to what you are going to present, then I think that you should take a step back and ask yourself questions. So to me, those questions need to be asked. But for the Attorney General now to be convinced that he has a solid case and is in terra firma, hard ground, I think then he is good to go. Those decisions might not be taken lightly. Remember, there were instances where, particularly the NDC was told that, you can't get anybody convicted. You not be you label as corrupt. You couldn't get anybody convicted. Now they'll be labeled corrupt. Let's see. Now they say some of them have started singing songs. So let's see where the songs will end. And I'm very glad that the Attorney General and the Deputy are quite good people who have used the court for so long that before they move on to prosecution, they know that they have enough evidence. And that's what he told us.
Is there a difference? Because most of the people who you end up appointing to the position of Attorney General are persons who maybe have spent their time either in civil litigation or even when it comes to criminal cases, they are usually the defense lawyer. Is there a difference between the work of a prosecutor and the work of a defense lawyer? So much so that if you are picked as an Attorney General who's never been in the position of prosecution, you might struggle. Is there that difference?
There's a bit of a difference.
Okay.
You have been at the point of defending for so long. Now you have to go after the people. Part of your defensive thinking will be kicking in.
Okay.
That this is what the person will be looking at. This is what the person might be looking at. But it helps as well. I think the better one is to be a prosecutor.
Okay.
And now being a defender.
Okay.
A defense counsel. That way, you know what usually the prosecutors look for than being the defense counsel and now being the prosecutor.
So it's easier to fit into defense from prosecution than to move from defense to prosecution.
It's easier.
Okay.
And I remember when the current OSP was appointed, he was a student of the current AG.
Okay. All right.
Yes. I think he even worked under the current AG.
Okay.
The current AG made that comment that it will be funny to him because he used to be a very good criminal defense lawyer, and now moving to be the prosecutor. So I will not be too surprised if the current AG also finds it a bit funny. However, he's working with a team.
Yeah.
So
and he's also been in that position before as deputy AG.
Yes.
Yeah.
He's working with a team. Yeah. So, and he has experience of being the deputy AG. So I believe that all round they will look at. You see, when you're going to court, you need to be asking yourself, what is the other lawyer on the other side likely to be thinking about? So being a former AG and a former prosecutor and now being the AG, I think he has enough experience to execute their job well.
There's also this view that I think is a man who is currently deputy at Yoko who told me this. He says there's a difference between what you're looking for as an investigator and what a lawyer might consider. So I gather facts for you. You have to decide which ones you're going to use to prosecute. Is there a difference in that? Are lawyers and investigators looking for the same things?
No. Sometimes the lawyer might be overtaken by his emotions.
Okay.
Yes, but the prosecutor will know that the court is not a place of emotions.
Okay.
It's a place of evidence. And the prosecutor will be asking himself, will the judge accept this thing?
Okay.
Is it not too light or too straw, too much of a straw evidence for me to use? So that is why you see that even here in Ghana, there are certain cases the police say, we have sent it to the Attorney General for advice. Because they are not sure whether this is enough meeting the threshold for prosecution. They really want somebody else with the professional eye to look at it. Now, the one of my lecturers gave a story about some guys were buying food near someone who was frying bullfruit.
Okay.
And one pushed somebody into the fire. And they arrested, and he ran away and they arrested those around. Now, the police took him to court. But you can only arrest when a crime is committed by someone or you suspect the person has committed crime.
Okay.
Not he was present when someone commits a crime and runs away.
Okay.
So when they went to court the following day, the lawyer raised this issue that you can't arrest somebody and bring him to court because the brother has committed crime and ran away. But the one looking at the evidence, the judge said, quickly the police showed the pictures of the burnt body and said, oh, my lady, if this was your son, will you grant bail in this situation? And the lawyer also asked, my lady, if this was your son that was wrongly arrested, would you also like to keep him? You see, so I'm trying to bring the situation of emotions and evidence. Okay. In this instance, that was not the guy who allegedly committed the crime. He was just there with his brother or friends. So sometimes the investigators go looking for emotion. And sometimes, let's be fair, lawyers also use emotion.
So, yeah.
And sometimes judges also use emotion.
Yes.
There is something called inordinate major premise. It's not really written, but they occur in our mind whilst we take decision. For example, if you are a judge right now and your husband is called Senna, and Senna annoys you before you go to court that morning, and the first case you have, the person is called Senna, let's be honest, you'll be wondering, oh, is that how all these Sennas are behaving? Your anger on the Senna in your house, somehow, much as you try to control it, will come on to the Senna you are meeting. It's not written anywhere that you should do it, but it works on almost all of us. So sometimes everybody uses the emotion, but it is the evidence that is used to convict. It is not emotion. The law does not deal with emotion. The law does not even deal with trifles, minor things. The law deals with concrete and big issues.
I see. Well, if you just join us, lawyer Theophilus Dzimega is in studio with us. We're having a conversation. We'll let go of him at some point because he has other issues to attend to. But now let's come to the case in question. Because newspapers are publishing the fact that what he's being held for is diversion of funds. Now, when the Attorney General was reading the facts, I don't know whether I should call it facts or the...
in fact, these are the same words that might be coming into the charge sheet.
So
you can call it facts.
Okay.
Yeah.
When Attorney General was going through, there are a few things he said. He said, one, the man signs the contract, then pays the money into his the account of his private company. The money is then transferred to the vendor to whom the money was. The money was intended for, not all of the money, part of it. So I think that was the only transfer, or there was another transfer that adds up to $1 million to the vendor, but keeps the rest of the money in his accounts and starts using it. When you hear that, do you hear only diversion?
No.
What do you hear?
You don't hear only diversion, misappropriation. There's also stealing.
Okay.
Stealing just means denying somebody the right to use something which is rightfully theirs. There's also stealing. It is not just people who takes people's goat or take somebody's sheep are the only ones who are stealing. This is also part of, it's called stealing, because the purpose for which the money is to be used you took it out of that purpose and it is not being used for the purpose. So you deny people who are to use it. I read something on a platform that when recently someone was appointed to that position, someone said, he asked, what is this one to that signal bureau and you are happy? Yeah. Not knowing the position is better than Minister of Finance. I read it and I was like, wow, it's true. So it's not only diversion, there's also stealing. Then, of late, we have had the situation where a financial loss to the state has also come in. So there's a loss to the state as well. So there are a number of charges in there. On the top of my mind, much as you can get aggregate of charges, usually very good prosecutors go for the ones that they can convict you quickly. Yes, they can convict you quickly so that you don't waste so much time. For example, if stealing will give you 25 years, causing financial loss will give 25 years, and you realize that you can prove stealing quickly, you go for that one.
Oh, I see.
Now, yes. Then
so it is the one which the facts you have available can easily help you prove.
Yes, you can have all the facts for all of them. But you look at it, you are in doubt as to whether charge A will really stick. So once you, the one bringing the charge, you are already getting doubt, then you'll be like anybody who sees it might also doubt. And remember, you can only convict based on beyond reasonable doubt. So if you, the one bringing it, you're already having doubt, why bring it? So you go for the quickest one for which you are likely to secure conviction. Now, there are certain charges that they follow from each other. For example, you hit someone, someone dies. Now, you go and try the person for murder. You fail. Then you come back to try for causing harm. No, they all flow. So the person would have gone to say, hey, you could have tried me for causing harm and murder. Or they flow from each other. So having failed here, you can't try me there. So you have to be careful about things like that. However, there are some that are so distinct that you can go for A, get the conviction, take your time. When you are convinced that you get for charge B, you file for charge B too, and you get that conviction as well.
You can do that separately.
Yes, you can do one, and provided they don't follow from each other, like as I give you an example, causing harm and death, or causing harm and attempted murder. Now, you don't go try attempted murder, come and sit down and say, now let's try causing harm. You could have done the two. That's what the defense would have been. That you could have done the two. So this is, we have been convicted or discharged or acquitted of the first one already. They follow from each other. But if they are distinct, like you are going to rob, then you kill someone by the way who is not part of the robbery thing. You can you can go for the robbery, come back and go and get the charge for murder on the way too, because they are not following from each other. You get what I mean? Yes. Then in those instances, you look at which one can I secure conviction quickly. So perhaps you secure conviction for the robbery. The person lies in cooler, start to reflect and goes like, well, I'm already here. Let me plead guilty for the other one so that maybe the two run concurrently and I am gone. So those are some of the things that the Attorney General can do. They might have several charges, but they might not flow from each other. Perhaps maybe out of the 7 million for today, something was taken. Next year was another 10 million. They might not lump all. They might do the 7 million, come and do another 10 million, and get conviction for both. Yeah.
So all this will be playing the minds of the Attorney General in making a decision as to how to proceed.
Yes. Remember that these are some of the very early cases they have. So each step they take
is critical.
Will be very critical. And the AG and the deputy would like to take steps that will lead to success. So that people will not say, hey, there have already been this issue about rub my back, I rub your back, NDC, MPP are all the same. Oh, you listen, this will not lead to anything. But I think the next 4 years or the next 3+ years will not be rub my back and I rub your back. There will be real action. So both Justice Semsai and Dominic Ayine, lawyers, AG and Deputy AG, will be careful at the steps they take. They will not just be walking to say, let's rush to court and get the person acquitted or discharged. No. They will calculate very, very well. Trust me, Dominic had his house surrounded some time back, and his laptop and iPad and stuff were taken. You think that will not be ringing at the back of his mind? Okay, he has to do a good job, and he will do a good job.
How do they avoid that? Because you see, both of them, I've spoken to Dr. Sai, in many other cases where he is having to defend former appointees of John Mahama, mostly, when they were in power between 2013 and 2017, the early days of 2017. And then you are talking about Dr. Dominic Ayine himself. Not only was he investigated, he also, in some way, suffered some, including that famous contempt matter at the Supreme Court, where how crucial is it that at least they avoid that clouding their judgment like they did it to us? We have to show them some. Should that be a basis for anything? And to what extent should they avoid that?
Senator, I said this somewhere that people have been saying what is happening now is witch hunting. Indeed, if there are witches to be hunted, they need to be hunted. I mean, if there are witches to be hunted, let's get that one clear. They need to be hunted. But at the beginning of this discussion, I indicated that Justice Semsai has built a niche for himself as somebody who defends human rights abuses. And I believe that will rather be the major thing playing at the back of his mind, that let's maintain this, because that is my conviction that we can do it well. You can maintain all the human rights to the highest level and still secure conviction. Gone were the days where you kick people, slap people to tell you the truth. Now we have a lot of electronic trails you can follow, etc. You don't need to force people to come up with the truth for you to be able to secure their conviction. So I don't think that they are doing tit for tat or butter for bread. No, that's not what they are doing. But the president made a pledge to the people of Ghana. At the commencement of this government, Senator, we were here, and we said we believe that if someone messes up, GM will kick the person out. I don't think those two lawyers would like to be the people to be kicked out. They'll do a real job. So it is not at the back of their mind now that do me, I do you situation. Rather, the people that the shoe was on the other foot the last time, and they were happy, and now the shoe is on this new foot, and it is stretching them. They are the ones who are worried. For these two, I think they will do their work to perfection. And yesterday, Honorable Dominic Ayine said something, that I am the leader of the bar. We believe that we want to see a different leader of the bar, not the leader of the bar that had issues that a judge even advised that if I were you, I'll pull out of this case and bring in the bar to become a propaganda platform for somebody else. No, I believe that Dr. Dominic Ayine will do a better job. And he started doing a good job. So let's get it clear. It is not do me, I do you. But if the witches are to be hunted, they need to be hunted. Simple.
I see. Because that's the allegation they've been raising. Because some of them even point to the fact that Richard Jakpa's name has been mentioned. That until recent time we're prosecuting him. So he's on a revenge mission. How can that be avoided in any way? Because it's the same people that they were, who are the same people who are having to work with President John Mahama.
Do you remember a certain Major Suleimana?
Not sure if you remember.
Oh, he was in the Kufuor government, either as National Security Coordinator or something like that. Major Suleimana fell out with Rawlings.
Okay.
One of those who ran away or something like that, or who went into exile. He was given a job at NPP then. He executed it. Now, do you remember a certain guy by name Captain Nkrabia Fadate?
Yes, I do.
Yeah, he he also had issues with the PNDC. Yes. And he was given deputy minister for interior. He executed it. That time we didn't remember that.
They had issues.
They had issues. Now, JACPA is not the institution. The institution is not JACPA. I think it's a coordinated, orchestrated, calculated effort to get the hawks to surround JACPA to render him ineffective. For the fact that I went through trial, you are the one prosecuting me, should not disable me from doing my work. I don't think so. It is rather those who were at the other side are now scared, to the extent that even the mere mention of JACPA sends shivers down their spine. No. I read somewhere, again, that JACPA might be embarrassing the government. Embarrassing the government for what? Have we decided that only Category A Ghanaians should work for the government and Category B Ghanaians should not work for the government? No. JACPA is working with a team. He receives instruction. They have intelligence-led operations and they carry out. I don't think that he is doing it for the sake of revenge. What if he was never appointed to that position? And the one doing it will not do it for also do it for avenging for JACPA? No. Let us not put sun in the path of people who are to do state work. Let the state institution work. Now, I only pray that tomorrow, when someone becomes the president, maybe after 12, 16 years, now the NDC, then they will wait to say, let us also change our ways. Because you see, it has only been one party that changes their way, that let us accommodate everybody. And when someone comes, he says, oh, no, forget about them. It is our way. This time, I think let them also have, it is our way, a bit of, let them taste it. Then we will all understand that it is not always your way. Others also have their way. But back to your question, I don't think JACPA is doing anything. I mean, so far what the Attorney General has told us, nothing unto us. They went with a search warrant. Then, again, when Ken Oforiatta said that he was going to sue, and JACPA's name was all over, his name was not on the writ.
Yes. His name was not there at all.
His name was not there. If he finds that JACPA trespasses property, he could have sued JACPA as well. So the people who are bereaved are not mourning, but those who are mourning more than the bereaved. It is a scheme just to disable persons from carrying out their job. But I bet you the job will be carried out to its conclusion. We have promised the people of Ghana that we'll recover loot, we'll recover this, we'll get people accountable. And now we are doing it and we say they are talking, so we cannot do it. No.
So you expect more of this from the New Patriotic Party? That this will be strategy moving forward? Let's target particular people and perhaps damage their reputation or use the media to defend ourselves as much as possible.
Yes, you know that, it's an open secret. They have a lot of the media space, more than the current government. They are affiliated stations, they are supporters who are stations. We know it. So now, years back, Radio Go was only the only voice in the wilderness, shouting, and it achieved a lot of things. Now, they are going to use their media, they are going to use the nano minority that they have. I didn't use micro, I use nano. I think nano is smaller than micro. They're going to use their nano minority. They have, put forward some of their so-called communicators. Then they'll put forward their new guys in parliament to also be talking. Then they'll get their media to carry out the story. You would have thought that with what was said yesterday, the discussion will be one that everybody will say, this is unconscionable. How can one person do this? That would be what they would have been talking about. But go and check all their discussions. They are talking rather about the fact that the rights of Kwabena Edubuahin. I don't know whether it's Edubuahin or Edubuahin.
I think it's Edubuahin, because it's related to
the professor.
Yes, the professor.
I heard on another radio station that he's not related to the
They are not
professor.
related. Oh, okay.
So some said he's the younger brother of
Charles Edubu.
There
are different accounts of who
is, yes. But the basic thing is that there's something that is allegedly be done against the state. Let us all be concerned about that. Let's give him the right that you are presumed innocent until declared otherwise.
Yeah.
But something has been done against the state, allegedly. Let us also look at that. Let us protect ourselves first before thinking about, we cannot just sacrifice only one person for the greater good for all of us. We can't do that. So let's think about it. That's why I said that somebody pays is paid 220 cedis and of tax, and someone gathers that tax and is using allegedly, and we are happy. No. So we expect that days to come by, MPP will be doing this. But if we have the first conviction, then they will begin to think about the strategy. I pray that none of the cases go beyond a year.
None of the cases go beyond a year?
A year in terms of prosecution.
Is that possible?
Yes, it's possible.
It can be done?
It can be done. That is why, you see, in certain jurisdictions, Senna, you build your case. You allow for like 2-3 months. Some even to half a year to build all your everything. You go to court, the trial is 2 weeks.
Okay.
You see, but here we don't build all. We go and give A out. Then the people ask for B. Then you go and give B. A lawyer is not present. Then the case is adjourned. Another lawyer is not present. Case is adjourned. No. You must expect that there's also going to be a lot of what we call interlocutory applications. Applications in between trial.
Yeah.
So the judge makes a decision, a ruling. Then they run to Court of Appeal to say the ruling is wrong. That takes another 1 week. Then the Court of Appeal says, hey, the ruling is not wrong. They run to Supreme Court.
Yes.
That takes another 1 week. Then they come back. But I believe that the AG can sit down with the Chief Justice to say, hey, just as you did with the election petitions and election issues, these type of cases, if they are filed today, let them be heard tomorrow so that we move on. If they are filed this morning, can we hear it in the afternoon so that we move on? So that they get people dedicated to get speedy trials. If these trials go beyond 3 years, so now we are not going to achieve anything.
They go beyond 3 years?
Yes. I mean, GM has only 4 years. We have started chopping the 4 years already. So,
but should this not be painstakingly done to ensure that, because there are many things, they said the wheels of justice grind slowly. Is 1 year not rushed?
No, Senna.
Because it's rare to have most of these cases running for a year.
Yes, again, as I said, can we build our dossier properly? Get timelines in our calendar, propose to the court. You remember the Judge Kwesing case?
Yes.
Remember the judge said we'll do the trial every day or every other day apart from Friday or something. Yeah. It was done then. You think it can be done now? It was done then. It can be done now as well. So if few years back, trials were being done on daily basis, it can be done still today on daily basis.
How is it important that time frame that you're mentioning? Because you say if it goes beyond 3 years, you won't get anything out of it. Why?
Nobody knows. I believe in my heart of hearts that NDC might rule for 16 years.
Okay.
In my heart of hearts, I believe so. That if NDC continues the path that we have been seeing since January to date, will be in government for a long time. However, should an unthinkable happens, that in the unlikely event that MPP wins 2028, the prosecution might not continue. Because prosecution is done or led by the Attorney General.
Okay.
So the Attorney General will see what their party wants to be done.
Okay.
If the Attorney General is of the view that this cannot secure conviction, as Dr. Dominic did, then the trial will collapse.
Okay.
Again, at the beginning of this discussion, I mentioned that we need a situation where we will ask ourselves two questions. Will we be able to secure conviction? Is it in the public interest? So if we'll be able to secure conviction, then let's push and have the conviction done. Now, you will also ask that, don't the lawyers need to do research and prepare proper defense?
Yeah.
That is why I am suggesting that we go to court today. Everybody makes their disclosures. You know the case against you. You know the evidence they have against you. We take 2 months. Everybody relaxes for the 2 months. You do your own research. When we start for the 2 months, after the 2 months, we do it for 2 weeks. That's all.
Well, there are many questions that I'm asking about how this will proceed, but now I'll bring you back to the facts. You said you used the word unconscionable. Is that to say that's what you see? That's how you feel when you heard it? The details that were put out. That if he did this is really unconscionable.
Yeah, driving here, I was with one of my guys, and the question was, so he couldn't have taken just a little, assuming he has taken, could have taken a little less than what they are taking allegedly, and or if allegedly he has taken, or couldn't he have used some to maybe go and give some SHS students or some market women to some altruistic behavior, altruism, so that others will benefit from it or something. Then, after a while, we will come back to the story to say, but this, if it is true, it's quite serious. After a while, we will come back to the story. So you will see that it shocked our conscience that, yes, I'm a lawyer.
Yeah.
I presume he's innocent
Until
proven guilty. But the question I always tell you is that much as the judge presumes you are innocent until proven guilty, he or she will look at a few things before granting you bail.
Yeah.
He looks at, if you are convicted, what is the length of punishment or jail time you are going to have? Then he thinks that you might escape because that looks so big a punishment. You think at the back of his mind, he doesn't know that you are innocent, but he's only saying, what if you do it? So before the judge even grants you bail, the judge too will be asking questions.
So he will assess the facts before him.
Yes, he will assess the facts. And the judge too sometimes could say, this looks so horrific. Well, he's not done it yet. He's not been proven to have done it. But part of me feels that the one he's done it against also deserves a bit of justice.
Okay.
So things like that, we are human. It is written, you have to be fair. It's written, you have to presume innocence. But part of you will be asking the question. As a lawyer, even when I told you clients approach you and you finish hearing their facts or their story, you're like, you take a deep breath. Like, oh, wow, is that it? Granted that you believe even your client. You don't ordinarily just stand up and say, oh, my client is innocent. You start from a different premise that granted that what he has told me is the truth. Then how do we go around it? So it is not a situation of just me being hit. I think that even some of the media men who heard the story, for the first time, I've seen something on a Ghanaian Chronicle handle. They showed an estate that they said this is what allegedly, I think, the money has been used to buy at Oyarifa. Then the comments that follow. I'm like, Chronicle 2 has taken this story. It means that everybody is shocked by what we are hearing. Let's give them the presumption of innocence. Okay. Now, I heard you use the word common criminal.
That was in the attaches.
Yes.
Yeah, that was I was reading attaches.
Yes. And I was asking myself, is he? But if you read the release further, you see that he was somehow referring to his client as a criminal. He keep asking, how can a criminal?
Yes. On
the
arrival and everything.
Yes, how can a criminal? Then you are asking, is he now accepting that his client is a criminal or something. Anybody that hears the story, Senna, except you have a dead conscience, you will be shocked. Because we are in this country where we were struggling to even raise money to pay workers, money to do ABC, and someone allegedly keeps only that amount. I mean, for all you know, that's the beginning. Other things may come up. We don't know yet. Others might come up. We don't know yet. Some may never come up. We never know. But if you hear this, Senna, unconscionability means something that will shock the conscience. For example, when you heard that people were buying $1 million lands in cantonment in hundreds of thousands, it shocks your conscience. That's the sort of thing I'm talking about.
It shocked your conscience?
Yes, it shocked my conscience. That, I mean, so assuming that I come to tell you that I got land at a cantonment at 10,000 cedis per plot, you will be shocked. I mean, you will say, no, there's something wrong. Absolutely. You will take a deep breath and say, come on, TK, are you serious? And I'm showing you receipt. Then you are like, you cheated the guy or something went wrong. That's the sort of thing. You see it and you are like, no reasonable person will do this. So you hear certain things, they shock. So this is one of those things that, having heard it, you are like, no. He's innocent. However, they say this is an allegation. If the allegation is true, that is serious.
Is that not where the prejudice comes in? Because I listen as someone in the public domain, and based on what I've been told, I'm convinced that this guy needs to go inside. But you go before a court, and perhaps the court might disagree with my stance. And does that not build prejudice against the court itself? That if the court listen, but even the court itself deciding that this one, the way the people feel, if I do this A, B, C, there will be problematic. Is that not where the prejudice matter comes in?
No. Senna, with all respect to you, who are you? Who are you that your view will be the one that will sway the court? In any case, the judges also listen. We agree. We have agreed on that. But there's also a principle that justice must be done, even if the heavens will fall.
Yeah.
Even if the heavens will fall.
But must also be seen to be done.
Yes, even if the heavens will fall, justice must be done and must be seen to be done.
Yeah.
So the person who will preside over the case, the judge, must make sure justice is done.
Okay.
Again, as I said, who is prejudiced against who? Because these cases, these facts are going to be filed in the court. We are not discussing the merits to say that if he brings this defense, this is what... No, the AG just told us this is what we have found so far.
Okay.
It depends. If you decide to go and use yours, excuse my language, to cook jollof with it, fine. If you decide to just read it, discuss within yourself, fine. If you decide to call Radio Gold to say that I heard what the AG said, is that the truth? Perfectly. But when it is presented in court, if always public court wins, or what is won at public court is what is won in the law court, like a lot of cases will be won in the law court. But emotions don't win matters in court. Hard evidence will have to be provided in court. So let's wait. Nobody will be prejudiced. Nobody at all. They are not discussing the merit. In any case, there are certain countries that this case would have been dissected. They would have shredded it by now. Get you potential defense lawyers, potential prosecutors, former prosecutors, they will all look at it. You watch it on CNN.
Yes.
You watch it, and at the end of the day, what goes on there, come on. Even today, there is virtually nobody who doesn't know what goes on around him or her. But they still empanel juries. Jurors are empaneled to have jury trial, even though they all hear the thing and form their opinions. But the judges tell them, pay attention to what you hear in the courtroom. And when you go home, don't discuss this case with anybody. Whether that is adhered to, we don't know. But they tell them, pay attention to what you hear in the courtroom. So what will be heard in the courtroom is what the judge will use, not what is discussed on Radio Go 90.5. I bet you.
Quite interesting. There was one point that was not lost on me when I was listening to the Attorney General yesterday. In fact, a lot of people will tell you that Dr. Dominic Ayine is one of the people who is not easily swayed. He is not easily swayed. People say it's difficult to impress. So for him to be saying, one, I have been giving facts that are enough for me to proceed against you. If you like, negotiate with me. If you don't like, I still have enough facts to then go to say, I commend those who did the investigation. How much credit is that to the investigators who did the job?
Yes, so I told you there are various angles to this. There are the team for the investigators. There are the team that the investigators will pass the information to, who will be able to make sense out of. They will remove the chaff from the meat and say that we are going to use this. This doesn't appear well. There are people again in that team that will say, no. We don't have to proceed with this.
Okay.
And in the years back, we heard about certain trials where we heard that people said they were told that their names were just added for the sake of adding them, etc. So, excuse me, the investigators would have assembled all the facts that they need to use. They would have maybe garnishi or blend them, paint them anyhow. But the prosecutors will now have to sit down with the investigators, having gone through the material, to now ask questions. If this was this way, why should it be that way? Can we look at this one again? Can you confirm for me this way? And remember, a number of these investigators will also be testifying for the prosecution. Yeah. So you need to get your story right from the beginning when you engage or you conference with the investigators. So a lot would have gone into the investigation. Then you see that these days, as I mentioned earlier, we are using electronic trail. They can follow what was done, either on phone, on the internet, some app somewhere. They can follow all this. If you listen to the Attorney General, he even talked about the flight changes.
Yes.
If this was happening like 30 years ago, it would have been difficult
to trace
that. But now you can do it. The person, I received a call from the British police one day. I received an email on an issue that happened at Heathrow. And I asked the lady, where do you get? He said, that was the email address you used when you bought your ticket. And that we were looking for everybody who was around the airport who might have witnessed something to see if they can tell us something. Because I was a bit quiet. Like, you use your email address to buy the ticket. That was the email address you used. So now they can trace a lot of things. They can follow trails. So they are not paper and hard evidence you carry everywhere. So I believe that the investigators' work will dovetail into what the prosecutors receive. Then the prosecutors will now be able to advise the AG that, hey, we are good to go. We are 70% sure we can secure conviction here. We are 90% sure we can secure conviction. This one looks like 10%. Let's not rather go. That's how the work is going to be done.
I see. Anyway, I'm sure there'll be a lot to talk about subsequently going forward. I guess I have to let you go at some point now. But before you go, you're involved in Akwetia matter, right?
Yes, I'm involved in Akwetia matter.
Okay. Well, what's the latest?
We are in court tomorrow. We are at the Supreme Court tomorrow. The last time we were in court, the idea was the Supreme Court asked that we should address them on whether they should give audience to the MP since he's been convicted of contempt.
Okay.
We took a strategy based on what we saw in court and also our difficulty in assessing court records.
Okay.
That will leave that decision to the Supreme Court. And they came up with 4-1 that they will listen to him. They will give him audience.
Okay.
However, there's one thing that I need to put out there. We have an issue with Gazette notification filed by the MP for Akwetia. He filed a Gazette notification dated 6 January.
Okay.
656.
Okay.
the number after 5.
January this year, 2025.
25.
Okay.
As the year when the EC gazetted, at the date where the EC gazetted the Akwetia or all the parliamentary elections.
Okay. 6th January.
6th January.
Okay.
However, we went to Assembly Press. We bought one Gazette publication, and it was 24th December 2024.
Ah.
Yes. So at the last but one sitting, the chair of the judges, Justice Puaman, asked the EC to address them on the discrepancy.
Okay.
And the EC filed an affidavit stating that the one we bought, which was 24th December 2024, is the Gazette they carried out.
Okay.
Then we also wrote to Assembly Press to confirm which of the publications is genuine. The one filed by the MP dated 6th January 2025. And the one we filed or we bought, which was 24th December 2024. And the Assembly Press confirmed that the one we bought is the one they have, but they don't have in their system any Gazette notification published on 6th January.
Wow.
Yes.
So are you going to back to the court to address that?
Yes, we'll draw the court. The court is aware.
Okay.
We want to see what premium they will put on that.
Okay.
Because it looks like somebody has their own form of Gazette publication. Okay. Different from what all of us have. Yeah.
But that's interesting. You secure all Gazette from the Assembly Press.
Yes.
Did they say they got it from the Assembly Press, or they haven't as yet?
They haven't answered it yet.
Okay.
Yes, even though we mentioned it in a subsequent supplementary affidavit, they've not addressed it. So we want to see, maybe they will address it tomorrow.
When the court questions.
When the court convenes. And mind you, their case is based on the fact that as at the time the NDC candidate for Akwetia filed his election petition, the election results have not been gazetted.
Oh, okay.
So they want to prove that it was gazetted on the 6th when the NDC guy filed his petition, 6th January, while the NDC guy filed his petition in December.
Okay.
But we have been able to show that as at the time he was filing the election petition, the gazetting was done. Not what they have.
Okay.
So wherever they got their new one from, nobody knows.
Okay. Yeah. So with what you have on record, it defeats that particular.
Exactly. But I would not like to go there.
Yeah, I understand.
Yes.
I understand. Anyway, in the meantime, the Akwetia case, are you convinced that the NDC won the seat?
I am very convinced. So now, I gave you something that will you be able to secure conviction? The same way I asked myself in civil matters, will you be victorious? I am very much convinced. And it's the very reason why I will doff my hat off to the Akwetia constituency chairman and Moro Yaro, who is also there, and the MP Okoyo. Not forgetting my brother Bernard Bediaku. He's done stellar work. So now this guy sends you message at 12 a.m. to say, hey, wake up, look at it for me, let's file tomorrow morning. Okay. And you have to do it. And he calls you, or I call him at 1 a.m. to say, hey, wake up, I'm looking at this, can we think about this? Every time he's sending WhatsApp, I'm sending WhatsApp, look for this case for me, I'm saying, let's look at this case. So I am convinced. And if he's not convinced, I'm not sure he will convince me that they won the case. Yeah, I believe that we've won the seat, and that seat must be added to the NDC lot.
The Akwetia seat.
The Akwetia seat.
I see. Yeah. La, thank you very much.
You're welcome.
Thank you very much for joining.
Before I leave, you know that Radio Gold is heard in my constituency.
Oh, okay.
Sepele is in.
Okay, because I saw someone say, there's someone who was saying, and let me see if I can find it. A focus says, I miss lawyer TK. I used to listen to him on Lolonyo FM.
Yes, I used to do legal education on Lolonyo FM.
Okay.
Every Monday.
Okay.
But I've been quite busy these days.
So you're unable to?
I'm unable to. But my folks down in Wahwe constituency, good morning to all of you, particularly my Zongo brothers who are fasting. They know themselves. I don't. The list is so long, from Olu to Salim to Klisman. There are plenty. My good morning to them, and then of course my young mother, Matafu Dzimega.
Young mother.
Yes, she's very young at 83.
Oh,
Yes,
really?
very young, yes, very
83
young.
is young.
83, yes, she's young. She won't sit at one place. She's all over, so she's still young. Yes, sister, good morning to you.
Okay. And thank you. You took an issue, you said where the issue of, and I'm sure you heard it, between raid and search.
Yes.
It was a big issue last week.
Yes.
You were saying that the use of raid was wrong.
Yes, I think it's wrong. It's a lawful search. It's a lawful search. Raid is you make a short, unannounced, and plan, unapproved dash into somewhere. You read about the rebels made a raid into the capital. Yeah. I mean, we are talking about search carried out with a warrant, etc. They secured the warrant, and the Attorney General told us he went and secured the warrant himself. So it's not a raid; it's a search.
I see.
Yeah.
Well, thank you. Lawyer TK Dzimega join us in studio where we discuss particularly the case that the Attorney General has put out, and perhaps the dynamics that will play out in court. We need to take a break, but